I think we may now start. Everybody have had their share with the water, so it is a good time, I suppose. First of all, I greet everybody who has come here and who will afterwards take a look at this video. I have heard that there's an interest towards it. My name is Jaanus Stern. I am going to be afterwards the first presenter of the tax residency here in Norway. I work as an attorney in Lea del Pilv. Among the other guests today, there is going to be Ole Christian Optet and Deli Dili from Bygaard Anleggspartner, supporting also Rutte Venkuyvene from Enterprise Estonia. And separately, we will have Henrik Selbar from law firm Jørstad from Norway. But the most important, of course, our event will be introduced and given by a short speech from by a representative from the embassy, Ole Øverås. So thank you, Ole.
Yeah, thank you, Jaanus, and thank you for inviting me to open this seminar here in the beautiful and warm summer in Tallinn. And it is also very great that we again are able to meet physically, because I think we all are a little bit tired of all the digital meetings. But we are also have some people with us today digitally. And being in this place is also a little bit special, because in some way this place symbolizes one of the important areas of contacts between Norway and Estonia, the wood house buildings. Because exporting of wooden houses is one of the most important export to Norway. And Estonia is one of the most important producers of wooden houses for Norway. And there are thousands of cabins all over the Norwegian mountains that have been built here in Estonia. And I would also like to use this opportunity to thank the new board of NECC for their effort to revive the chamber again. Especially thanks to Joar, which is not here today, but also to Sandra, that has been organizing this today together with Jaanus. As you know, one of the main tasks of the embassy is to promote economic collaboration between Norway and Estonia. And in that endeavor, the NEC is one of perhaps the most important partner we have here in Estonia. Even though we are also working with Estonian agency, but NEC is very important for us, and we are very happy that NEC once again are starting up a lot of activities. Norway and Estonia has a long tradition of trade. In reality, we can go back to the Viking times, where Norwegian Vikings came to this coast to trade, not only to kill as the Hollywood films depict them, but they were also good tradesmen and did a lot of trade. Today there are more than 200 active Norwegian companies in Estonia, and there are a lot of Estonian companies that are exporting to Norway. And Estonia exports much more to Norway than what Norway exports to Estonia, so perhaps there is something that Norwegian companies should look into. And I think one of the reasons that so many Norwegian companies have established themselves in Estonia and thrived in Estonia is that the legal system here is reliable, the courts are reliable, and there are little or no corruption. So the laws are being followed up on. But of course the laws in Norway and the laws in Estonia are not similar, and one of the things I think we will learn a little bit more about today is the peculiarities of the laws in the two countries. But Now I think I leave the floor to the experts. And once again, thank you to all for coming here today, and thank you to all that are following us on the internet digitally. Thank you.
Thank you, Ole. That was very promising. And from there will we continue. So let me, as said, I will be leading this through tax residency in Estonia and Norway. Our today's seminar is gonna put the main emphasis on the income tax. Tulumaks in Estonia or intäktsskatt på norsk. I think, and why this tax, for a reason, is that this is how we tax the profit in various matters. But to take a moment and give a short introductory about the law firm I'm coming from, Leadell Law Office has its offices in three Baltic states: Estonia, Latvia, Lithuania. We have experts from the field of tax law and from the corporate and commercial law. And why me is that on everyday basis I consult these matters from the clients from Norway and from Estonia. So all the information going to be shared with you today comes from my practice, comes from the consultancies, the discussions I have had with the tax authorities in Estonia and in Norway. The information also originates from the Norwegian, mainly from the Norwegian skatteloven, from the Estonian Income Tax Act. The other most important law source is the tax treaty, considering income tax, the tax treaty between Estonia and Norway. And last but not least is the convention by the OECD to follow up on how to tax income. So these are the main sources which I will be relying on today. What will we speak about? First, always point out and read the fine print. This overview is about principles and handing out indicative descriptions. This seminar is not about solving your specific case, and every case must really be followed up down to the real documents. We unfortunately we cannot solve those cases today here. But what we will do, and what I will try to help you, is by giving you some anchors, some main principles to keep in mind when doing business, already doing in business between Estonia and Norway. So let's get down to business. Natural person's tax residency in Estonia. The main principle. The person must have a place of residence in Estonia, or the person stays in Estonia for more than 183 days in a 12-month period. I think if the second condition is quite understandable, then the second one raises questions. And the question is, what is a place of residency in Estonia? This means a place where the person is staying permanently. Permanent living means longer period, more than, for example, tourism, business travel, or a school field trip. And in Estonian law, a person can actually have multiple places where he lives. Excuse me if from here in out I'm gonna indicate on he because I'm more used with that verb as being. And so in Estonia, it is possible, for example, that a younger person has multiple places to stay. One is at the country, one is with the parents, one is where the person is while at school. Usually, how it is with the students. So I think this is rather simple. And in Estonia, the tax liability if the person is a resident in Estonia or has a residence in here, then the tax liability applies to all the wealth and the income earned in Estonia and abroad. So keep in mind. Now, well, but the conditions of a person being a tax resident in Norway. Here it's again easy to understand the numbers. We can all read those. And but in any case, the residency does not end until the time when the person has stayed in Norway for less than 61 days. Nor the person or the close one of the person, they don't have a housing in Norway. And now again the question is, what is a housing? Housing means a housing unit meant for living. But we cannot consider a building or an apartment even a housing unit unless it doesn't have a running water or a sewage. And reservation from the housing units must be acquired at least 5 years before the income year. So there is, let's say, a 5-year long delay. So that which must be taken into account. So this means that this is the period when the person must not have the unit. Let's follow on. What happens if a person is a tax resident in Estonia and in Norway? How can this happen? This can happen, for example, let's say that a person is a tax resident in Estonia fully, but at the same time the person also has a spouse in Norway who lives there, or they both rent an apartment in Norway, which can be used quite well. How is the collision then solved? So, first condition. It shall be solved on the basis where the person has a permanent home available. But on the previous example, what if the person has a permanent home at both countries? Then it's down to the habitual abode, where the person stays for the most of the time. Then we come down to the question to which country the person is national. And finally, if we cannot follow up on those previous conditions, if the person still is a resident of both countries, then it is a question about mutual agreement. But according to the tax treaty between Estonia and Norway, there are always exemptions, a lot of exemptions, and the most usual ones is considering the workers. And the exemption is that the person is taxed, the worker is taxed by this country where he works. This is the easiest one to follow up. And in practice, it is again possible, that for example the person, let's say, working in Norway, and somehow you manage to get away with lower tax rate compared with Estonia. And then you come take your income and use it in Estonia. Then the Estonian tax authority has the right to tax you, to come up to this percentage which is meant by the Estonian laws. So this is usually also the case in practice for the natural persons. Company tax residency in Norway. I think this is the most interesting question, because the emphasis of today and the emphasis of the trade between Norway and Estonia always relies on companies. First, it's a question based on which countries the company is founded and where the country is registered. If the country is founded in accordance with the Norwegian company law and registered in Norway, then the company is tax resident in Norway. If the company is not registered in Norway, then it's also a question about where is the actual management of the company. The actual management is considered mainly about where the day-to-day business is being executed. Where is the board? Where are the board meetings held? Where are the contracts signed? So this means that usually the Norwegian tax authority comes with these questions, like what is the address of the company's office and where the board members, where do they live, where do they have their meetings, where is the daily manager? Is daily manager located in Norway or in Estonia? If the business activities are commenced both in Estonia and in Norway, then how is the proportions divided between both of the countries? But if according to the tax treaty, a person is considered a tax resident in Estonia, then the person is tax resident in Estonia. But so in practice, the companies usually they want to register themselves in Estonia, try to be a tax resident in Estonia, and then commence their business in Norway for some obvious reasons. When is a person tax resident in Estonia? A person is a tax resident in Estonia, or a company is a tax resident in Estonia if it is registered and founded in Estonia. And here we have now a collision. A company is registered, founded in Estonia, but commences the business in Norway, which means that the person is a tax resident of both countries, of both of them. How do we solve it? So, how do we solve it? The first question actually is this, or the first questions which are supposed to be asked are the same which the Norwegian tax authority usually asks. This is mainly, I would say, based on where the actual business is executed. Because formalities are good to follow up, but it is always where the source of income comes from. So let's get and it also comes to questions about which kind of income we try to tax. Let's say business profits. Now this is important for especially for Norway, because in Estonia we do not tax our business profits. We tax them when taking out dividends. In Norway, business profits are taxed through the permanent establishment, but only so much of them as this permanent establishment is at the state. So now we must move on a bit and try to understand what is a permanent establishment, because this is the most important term, I'd say, when trying to allocate the company tax residency. Permanent establishment is indicates on a permanent stay in time and place, a degree of permanence. What is a degree of permanence? According to the OECD convention, it must be around 6 months at least for a company to have its business in one country. It is also possible to have shorter stints, and then the 6 months is coming together. Permanent establishment in a territory before Corona, before the digital industries, it was very easy to understand where was the factory, where was the shop, where was the office. Nowadays it's mixing up. Therefore, the framework is being updated. So are the Norwegian tax laws. But from the previous comments, it still points out that, for example, if a consultant, a private consultant, works from his own home office, then this country becomes his permanent establishment. But again, by going back, these are the examples of the most common, the most usual permanent establishments there are. But what about subcontractors? Then it's again, where is the object where the subcontractors are working? If an Estonian company wants to have their business in Norway, they hire subcontractors from Estonia, but then sending those subcontractors to work in Norway, then it raises a lot of questions. Even more so if the workshop, if the factory or the object is controlled by this Estonian company, then the tax residency would like to go there. Or I would say that the Norwegian tax authority becomes quite active on this on this question, because permanent establishment, it's about carrying on business through a fixed place, and means the persons who in one way or another are dependent on this enterprise and upon this object where the business is commenced. But what about brokers, agents who are working for the company? Thank God, from this aspect, they are not influencing the matter. The permanent establishment is not being decided upon where the brokers or the agents are, because brokers and the agents, by the essence of their field, how they act, are supposed to be free and without any permanent residency. But there is also a possibility, for example, that one company is controlled by another, and then sometimes those different companies, they want to shift the tax residency, or they at least want to shift it in a manner which contributes them the most. The unfortunate news is that it doesn't help. Companies do not, they cannot influence it in that way. It comes down to where your business is, where are the workers, where do you get your profits from, and so it is. Now let's go back a bit. So with business profits, it is mostly about where is the permanent establishment. But what about the dividends? This is now important for both countries. Dividends, as you can see, I have written out from ourselves. If they are paid by the company, which is a tax resident of a state, to a resident who is tax resident of another country, so we have two different countries involved, then this means that the other country, the country where the addressee or where the one getting the dividends comes from or has his tax residency, then this country has the privilege, saying that if a Norwegian company pays out dividends to an Estonian tax resident, then Estonia has the privilege in this case. But there are again exceptions from the main principle. One of the exception which I would like to point out is for the beneficial owners, and which with beneficial owners, let's say countries go to a long mile. I would just say out that it's better to be careful in this matter. And the other exemption is if the dividends are paid by one company to another company. Then, let me check my notes. So, if the dividends are paid by one company to another company, then it comes down to again that this company who the dividends will get, where is the company tax resident? Where a company is not a resident of a contracting state, the other state may not impose any tax on those dividends. This means that if a Norwegian company pays dividends to Estonian company, then Norway cannot tax it. Unless, of course, both of the companies from Norway, or we again come down to the clause of the permanent establishment. If the permanent establishment is again in Norway for the one who gets the dividends, then Norway has the right. So, again, where is the permanent establishment? Where are the workers? Where is the business? How is the business commenced? If the business is commenced in both the countries, in Estonia and in Norway, then the tax authorities, they usually look how are the proportions divided between the both of them. And we cannot also rely that the company can stay hidden. The tax authorities, they communicate, they share information, because in the end they are also fighting for their profit, their income. Now, so this was I tried to make it as short and maybe as simple as possible. So again, I would like to point out, where is the company registered? Where are the members of the board? Where are the board meetings held? Where does the income come from? Where is the registered office? Where are the objects? Where they work with? These are the important questions. With natural persons, it's a bit easier. Then it's usually a simple question where the person stays the longest. And then comes the exceptions. So, do you have any questions? Can I consider that the main principles were, or at least I repeated myself enough so that we can remember them? I think so. Thank you. Then this is it about tax residency in Estonia and Norway. Now we can share a few snacks, a few drinks. But before that, I will also give a word to Argo, who will give a short introduction about the venue we are staying today, about the factory house, and for which we are quite grateful to have this event for. Thank you, Argo. Then it's also going to be recorded.
Yes. Okay. Yes. Thank you, Janos, and welcome on behalf of Tehasemaja. It's factory house, and a few words. It's part of the Estonian how to say it, open air museum. We are at the present stage, And probably most of you have been inside the territory. It's 100-year-old, 200-year-old log houses, old buildings carried on from different places all over Estonia. And 10 years ago we started a dialogue between Estonian Woodhouse Association and the museum. Why not to show the building technologies and possibilities, what is in 21st of century. Why to wait 50 or 100 more years? And when Estonia celebrated 100 years, then I took the lead of the project and gathered more than 100 companies that contributed with their materials, products and services. And we made a present to the Estonian state and the museum. And here we have inside our sector showroom, so you're welcome to step in. So we tell the story of Estonia as a country of forest and some reference projects, and also show their different possibilities how we can produce and build the wooden houses nowadays. And also here are the offices for daily work, and we wanted this building to be outside of the museum area, so that anytime the visitors can come also and not pay entrance fees and so on. Yes, you are welcome to follow me together with the snacks and drinks, and we can have a little tour. Yes, thank you.
Have we started? Yeah? Okay. First of all, Jonas, thank you for a good presentation about tax residency and taxes. My name is Ole Christian, and I come from Big Anleggspartner. We are a company providing services for Estonian companies within construction area in Norway, ranging from marketing and sales to general advising and help with contract negotiations, etc. Firstly about us. Established in 2017. In the company we have more than 10 years actually of experience when it comes to aiding Estonian companies in Norway. We are located in Tallinn, and in Norway we have companies in both countries, and we have 2 employees here in Estonia and 2 in Norway. We're going to talk about contracts in Norway, the different types of contracts that are used in business, construction business in Norway. It's very important to understand that although we have standard contracts in Norway, all of them are negotiable. You can have your own terms in these contracts, and also the clients will always try to put their terms into these contracts and make amendments to the standards and so forth. So it's very important to be aware about the standards, know them, and how you can what is common practice when it comes to contract agreements and so forth. In Norway there's generally a strong focus on formalizing the contract so that everything is as agreed upon as possible before you start the project, so you avoid discussions later on. We can look a bit into how a contract mainly look at, the main points. There will be a definition of the project, of course, and you will have a hierarchy of documents in the contract, which ranges the documents, how they play against each other in a possible future conflict. You have the contract components, you have rights and responsibilities of the owner and contractor, project schedule, payment methods, warranty and delay penalty are the main things. And then in the contract there will be a hierarchy of documents that will be used in a project, let's say, where you have ongoing things, you get into conflicts perhaps or discussions, and then there will be situations where you look into which document is overruling the other. And here we have set up how we ideally see that you should build up this hierarchy to best promote your interests. I doubt that this will be the hierarchy that you finally agree upon with your, let's say, main contractor in Norway or developer or whoever you are working for there. Because right now it's not perfectly balanced. Now it's very much focused on your terms. So on the top you have the contract, and then you will have the clarification meeting report where you agree on modifications to contract or other things. You have your offer, and then the Norwegian standard, and then the inquiry from client and the client's administrative provisions. Normally the inquiry will go higher, and also their administrative provisions will normally be somewhere higher up to balance this more out.
Ole?
Yes?
Can I just ask a question?
Yes.
You're totally right. I was working in this business in many years, and I was pushing my suppliers, contractors, to sign the inquiry above the offer. Because there's so many documents in inquiry usually, and main contractor or the client want to be sure that you gave the price according to everything.
Yes, that's right.
But the point is, even if it's pressure too much, you must be very, very careful what you write in the clarification meetings or minutes of the meetings.
Yeah, the clarification.
This will really save you a lot of time and a lot of discussions. So it's a good thing to remember and very important to do.
Very important to take up your wishes and interests in the clarification meeting and clarify what is included and not, or what kind of solutions you have offered. The Norwegian standard is basically developed through a cooperation between the government or public and private. So they are meant to be balanced between the contractors, developers, owners, and those executing the work. They're meant to be time-saving, and the best is to maybe have a NS contract with no changes in them. So you can also make, when you receive an inquiry, or if you make an inquiry, you can also, it can state that it's an NS84 that applies, and then that basically means that all the clauses in NS84/05 is accepted, and you can make your offer based on that, and also when you inquire it will be the same to the company offering the services. Or
One more question for you, Ola. Is it possible to negotiate the standard? Let's say if they want you to have 8415 on, you mean it's 8409. Is it possible, or is it just decided?
It's always possible to negotiate. There is no law saying that you have to use this or that contract. So you can, if someone is offering an 8415 contract, but you say are only exporting materials, then it maybe makes no sense to have 8415 if you're not doing anything on site or performing work locally. So you can always ask for a different NS contract, or you can basically change the NS 8415 to be more similar to 8409 or vice versa.
So may I ask a question?
Yes.
So can a person or a company then just come up with his own version of the contract they prefer? Are they obliged to follow up with the Norwegian standards?
They can make their own contract based on any NS standard with their own terms. Change the clauses basically. So if you have an NS contract where there is very few comments, then NS 8415, if it's that contract, then basically all those clauses in the NS applies. But if you have comments on the different clauses, then this is most likely a change to the original Norwegian standard.
But what if the parties just agree on the basic terms, which are the price, the building they want to build, and the due date, and they don't write anything else? Does then the Norwegian standard also apply or not automatically come into play afterwards when there are any disputes?
It depends if there is referred to the Norwegian standard, or it can also be referred to your client's contract with their client, for example. So then you suddenly have a responsibility to check what is their contract saying, for example. But you can work on a contract that doesn't say anything about the NS, and you have only scope, contract sum, and end date. That's possible.
And then later I cannot rely on the Norwegian standard if I don't make a referral to it.
Hi, yeah, well, I'll jump in.
Okay.
So with that, there's no requirement to have any sort of formal contract, although you probably will find that some sort of Norwegian standard, possibly a little bit of a Frankenstein one that's been changed up a bit, will be normal. But it's perfectly possible to have a purely verbal contract where nothing has been agreed solidly like that. In those cases, then it's quite often that the court will revert to what is the Norwegian standard that would apply in that instance. Obviously, it's very hard to say absolutely on every single case, but that would be the general rule.
Thank you, Del. So, next slide. Common Norwegian standards in construction. Here we have listed some. We have 8400 rules for procurement for building and tender construction in tender competitions, and we have 10 rules for procurement to building and construction in the event of competition with negotiated procedure. And we have 05 Norwegian construction contract build only for main contractors. And we have NS 8406, which is a simplified Norwegian construction contract build only for main contractors. And you have 15, which is the construction contract build only for subcontractors. 8416, which is the simplified for subcontractors. And you have 8407, which is the design and build for main contractors. And then there is 8417, which is the construction contract for subcontractors, design and build. Sometimes you can see that there's a difference between 8405 and 8407, which differs on who has the design responsibility. Sometimes you can encounter situations where these are also mixed up in the contract chain in the same project. So it starts with 5 and you get the 17, or it is actually 8407, but still you get 8415 and so forth. But normally they should follow the same number. Then we have also some other Norwegian standards for engineering, for advisory assignments, general contractual provisions for manager assignments, for purchasing building materials, 8409, and then we have 3405, regulation of contract sums due to changes in wages, prices, social expenses, etc., which is quite often applicable in long-lasting projects and where there are delays, among other things. And you have 8430 takeover of building and construction, and you have NS 3450 project documents, operation manuals and stuff like that. How Norwegian standards can be used on a construction project. So here we have the hierarchy of how the contracts normally follow each other. So you have in one case where the owner have designed the project, the landlord or the developer have already done all the designs. They then give a 8405 contract to the main contractor because that's a build-only contract. Then the total contractor normally makes a inquiry to the subcontractor that is based on NS 3420, where all the amounts are and all the details are in the post description. The subcontractor is not responsible for the design when you have a 8415 contract, and then when you finally sign as subcontractor the NS 8415, you could have a NS 8409 based contract with your supplier. And then we have the other side where the owner has done only preliminary designs. There will be an 8407 contract with the main contractor who gets the responsibility for the designs, and then the subcontractors can get 8417 contract or 8415 contract depending on what kind of trade you're delivering. And the same also here for the subcontractors, can or cannot use the NS 8409 purchase agreement. Any comments or questions from my other teammates? No? So about the NS 3420 standard. NS 3420 is basically the main framework for all construction in Norway. It describes the tolerances, the design rules, when it comes to materials, how it should be executed, and so forth. And it can also be used to control the quality after you're done and things like this. NS 8405 build-only contract. This is a Norwegian construction contract between owners and main contractors, and is most commonly used on public sector projects where municipal or the state have done all the design works. It sets out strict notification procedures that must be adhered to. The owner can make changes to the agreed design, and the main contractor may be obliged to carry out the change. The main contractor must notify if the change means they are entitled to increased payment or needs longer time. And should the main contractor identify a required change that leads to more work and was not foreseen when the agreement was entered, they must notify the owner if there are grounds for increased payment or time. And in relation to 8405 contracts, you have different forms where you have 8405, that is the agreement for execution of the work, and you have form 8405B, which is the warranty or the security for the main contractor's collateral to the contractor in contract pursuant to NS 8405. And then there is 8405C, which is the builder's security for the contractors and suppliers. NS 8406, building only contract simplified. It follows the same principles as the NS 8405, but it doesn't have the same strict rules to notifying any changes or delays or things like that. And it's mostly used on perhaps smaller, simpler projects where there is maybe only one contractor at a time and you don't need to interact with other players on site. NS 8407, design and build contract. The main contractor has more choice with equipment and technical solutions and has the responsibility for the designs. However, even though the main contractor has taken over responsibility for the owner's design, they still have the right to invoke errors in the design within 5 weeks of the contract signature. If a design error is detected by the owner within 5 weeks and it is advertised on time, the error is the owner's responsibility and risk. If an incorrect owner's design is uncovered after the 5-week deadline, the owner's design error will be regarded as the total contractor's responsibility. Like NS 8405, NS 8407 has building forms A, B, and C, used correspondingly as mentioned previously. NS 8405, subcontractor, build only. This is a contract between the main contractor and the subcontractor. It is similar to the contract that the main contractor has with the owner, but it has some significant differences. Total contractors remain ultimately responsible for the design, and subcontractors work according to the design they receive. But the subcontractor is always responsible to stay updated on the latest design. This is really important. Main contractors also retain the right to take over the subcontractor's work if there is a delay. NS 8415 is suitable for projects where the scope or organization of the project requires formalized in-notification rules with strict consequences for non-notification or extensive duty to coordinate with all actors in the project. And the same forms A, B, and C applies also here when it comes to security. 8416 is subcontractor build only simplified, same basically as 8406, but goes for the subcontractor, suitable where you are subcontractor for a small project perhaps, or you are alone on site. Subcontractor design and build, NS 8417. This is the contract that are being used between the main contractor and the subcontractor, where the subcontractor will have also the responsibility for designs and take over the responsibility for the design. Here you have more possibility to make your own innovations, suggestions, influence other trades' designs, and so forth. It's often used when the work is technical, like plumbing, ventilation, electrician works. Can also be structural designs and deliveries as well. So, just a couple of pros and cons between 8415 and 7, depending on what kind of business you have. But with 8415 you have less responsibility. You have also possibility to earn bonus or extra income if you pick up errors in the client's design, changes and additional works, and you also have more access to adjusted amounts. Cons is that you cannot be so innovative, you have to follow what you are being told, and payments only for work delivered actually on site. Then we have 8417. Pros is that you can be more innovative, you can also influence others' designs and deliver more services, and you can also have a better cash flow by invoicing hours spent on designing and so forth. Con is perhaps that you have the responsibility for the design errors, long test periods which can affect the final payments, and main contractor may have an NS8407 but still have subcontractors accept the responsibility, although it's the main contractor responsibility. So NS8409, regular terms for purchase of materials. The terms lay out when the purchase is complete, the price, payment terms, delivery terms and dates, delays, product shortcoming, warranty and cancellation. Good to have if you are buying something, and it can be so if you are delivering things and you are late or something with your delivery. I believe this, yeah.
I think we should also inform that this is under revising by now. The last revision was in 2008, and it's quite old now. So now they're building the committee to do the new revision of this contract. As much as I know, it will stay with on the main focus the same, but there will be much more advanced products you can sell on this or buy on this contract. Let's say all the products that will be permanently built into the building, it's actually building materials. Even some products or some parts of the like fire protection or ventilation system that are prefabricated, they can be buy on this project, on this contract as well. So I think people that will ask about 8415 can consider if 09 is also suitable. It's not only the bricks or the simple windows that can sell on this project. The main difference in my eyes is that 09 is only for the delivery. You will not do any work at site. Or do I'm wrong?
8409 is basically for materials suppliers, and as I understood, this new revision will also include building materials that are put together, or it's a combination of building materials, so you put it together also on site, say modules or wall elements and things like that hasn't maybe been part of this earlier, but I believe this is going to come into the standard now. Mm-hmm. And there can be clients that ask for this kind of contract based on 8409 to secure the delivery time, quality, and all these kind of things in their project. Yeah. A little bit about delays in projects. All contracts normally, of course, have a complete date. So instead of the owner bringing a claim for compensation for late completion of the works by the contractor, it is standard for the contractor to be required to pay daily penalties. I don't know how that is in Estonia, Janus, but...
Yes, thank you, Ule. Yes, this is also a possibility in the Estonian law, and it is quite used. The only problem with the daily penalties is that later we must go to court if the payment is not voluntarily, and sometimes there is not anymore the company to ask for those penalties. That's more of the regular issue. So that's why the preferred answer in Estonian system, at least, is to reduce the amount of the final payment, or to play around with the payments being made.
Thank you. Yeah, and hence to that, The forms for security are used in Norway to gather bank guarantees or insurance guarantees to avoid situations where you cannot get the daily penalties or the supplier cannot deliver everything or to the end. The daily penalties are usually 1 promille of the total sum, but not more than 10% of the contract sum, and usually not less than say 5,000 NOK per day or something like this. So about payment, there are basically 3 different ways you get paid. You have a fixed price agreement, pre-agreed sum that the contractor or subcontractor will be paid to carry out either a stage or the whole works as required in the contract. Where you also make a payment schedule, when should what be paid, and how, and this will also be measured accordingly so that there is a control that you are in the progress the same far as you are with the payments. Then you have actual cost. You are being paid by the basis of the costs of labor and materials used on a running basis. And then you have cost plus, which is basically an addition, or if you have a fixed price agreement, then you will have agreed in the contract that if the work is differing from the posts you have or the description or the work you normally have according to contract, you have a different hour rate, and you also have a percentage addition to the materials that will give you the profit as well. These are the 3 main. About adjusted amounts, you will write contracts with a fixed amount, especially with 8415. This forms the basis for either increasing or reducing the amounts according to what you have actually delivered, according to amount controls as you go along in the project and invoices, and you're invoicing and you come to the final settlement. So this is worth keeping in mind when you're budgeting the project, that this might differ in the end.
Ole, I have one more question.
Yeah.
You have long experience Estonian companies working with Norwegians. What is the most common terms of payment? Let's say 15 days, 30 days, 45 days, payment plan.
Yeah, I would say 30 to 45 days, and you can invoice once a month on the 30th usually. So, and you invoice when you have produced 1 month. Then you control what is delivered, you send the invoice with 30 days or 45. Some might also ask 60, but this is too much, of course.
Totally agree with you.
And that was basically it from us. Thank you for your time, and enjoy the weather and the food and everything.
Sorry, Ole, I just forgot one question. Okay. Can I get you back?
Yeah, sure.
Yeah. One question. Norwegian companies usually ask both the guarantee and that outstanding payment as well. But in my practice, usually you can also discuss this. Do you have only the outstanding payment in Estonian or the guarantee? How common it is in your experience?
It's very common to ask for.
I think it's
to ask for both. But if you give only the retention, or they only hold back money from each invoice, 10%. Then usually this they will then keep 10% of the full contract amount. But if you are able to give additional security in form of insurance or the bank, then normal is that they keep back up to 5 or 7.5% of the contract sum. So if you're able to give some security, it is better for the cash flow in the project, actually. Usually it is like this. So it's hard to get away from the security without offering more in retention.
Yes.
I may also make a note on it, is that Ule's comments were quite valid, very good. The bank warranties are, in my opinion, also one of the best ones. But at the same time, they also carry a risk for the contractor, is that the consumer will use its rights, call in the bank guarantee, and then the disputes follow up about was the situation there to use the bank warranty or not. Because quite usually the warranty is given, they are used or they come to life automatically, just based on the formalities.
In the B2B world in construction, this comes into effect if the supplier isn't able to follow up his obligations when it comes to warranty. So let's say there's a faulty construction or something broke that is part of your warranty, and you cannot go there and fix it or pay for the damage, then the bank warranty comes into play.
Yes, and then there's also bank warranties which warranty the building process itself. It's for the process and then afterwards.
Yes, both construction period and the warranty period. Yes, both. Yeah. Anything else from the guys online? Okay, then I think I am done. Thank you.
Yes, thank you very much, Ule. Please, will you please continue, because your experience is much valued. We will right now continue with Henrik, and then we will again follow up with the comments and the questions, because you two are quite into this topic, considering the Norwegian part also. So, Henrik, are you with us?
Thank you, Janus. Can everybody hear me?
Yes, yeah. We can hear you.
Yeah. I will take that as a yes. Mr. Ambassador, ladies and gentlemen, thank you for inviting me here. Special thanks to, of course, Janus Stern, who I have been in contact with for some time now. I am sorry that I wasn't able to participate in person. I'll have to blame the COVID restrictions for that. Nevertheless, I hope very much to be able to meet you all at a later convenience. I need a few seconds just to get my technical resources up and running. So just bear with me, please. Here we are. Can you see my presentation now?
No. We are also fixing it from our end, from our technicians.
Okay.
So thank you for your patience. So, Henrik, now it's coming. Great.
That's good.
Mm-hmm.
And I'm going to improve it a little bit.
Good. Thank you.
Like so. Excellent. And you just bear with me for just another second. I will get it all in order here. Here we are. I think we have control now. I was asked to do a sort of comparison between Estonian and Norwegian building law. And My knowledge of Estonian law is limited to this law, the Estonian Law of Obligations Act. It is very good that this law has been translated into English. I think I wouldn't have understood much if it hadn't. The law comprises very many different contracts. But of course, the main object here today is to focus on building contracts. And I went through all the paragraphs, I think 1068 of them. And it was sort of difficult to find that many differences between Estonian and Norwegian building regulations. But still, I was able to find a few, perhaps, at least what I could interpret from the text in the law, legal practice and other sources and so on. Sadly, I haven't had time to go through, but some potential differences, at least, might be useful to check out before entering a contract across national borders. I have been informed by my good colleague Jan Stern that Estonian building contracts with customers follow the rules of every other service contract or the general service contract, as opposed to the rules concerning consumer service contracts. This is a little bit different in Norway, where we have a separate law which applies to construction of residences for private customers. This law, Norwegian law, is called Bostadoppføringsloven, which translates fairly into something like the law of building homes for private customers, or private people, if you like. So houses that are supposed to be lived in, a contract for building such a house with a private customer is regulated in a separate law in Norway. And this law, Bostadoppføringsloven, grants the private customers some additional rights, extra rights, privileges, which are not necessarily included in the Norwegian standard contracts, which Mr. Opseth just talked about in a very good manner. I will get back to some of these extra additional rights, but I think I have to emphasize already at this point that the most important difference is that provisions in a contract with a private customer, which is a contract for building a house meant to be lived in, private house, those provisions cannot be less favorable for the customer, the private consumer, than what follows from this law. So that means if there is agreed upon something in such a contract that is less favorable for the customer than what is stated in this Norwegian law, those provisions can't be enforced by the contractor upon the private customer. So one thing to bear in mind when entering a contract to build a house, for example, with a private customer in Norway, to clarify and to check out that the contract is not in violation to the rules in the bostadoppføringsloven. Anyway, as I mentioned earlier, it wasn't that easy to find that many differences. Most of the rules are similar or pretty close to similar, which is a good thing, I think, from a business point of view. I have pointed out a few perhaps nuances or differences. Most of them refer to contracts between a professional party and a non-professional party, a consumer, but not all of them. So the first thing I would like to mention derives from the Estonian Law of Obligation Act, paragraph 28. And that rule says that it concerns restriction on claiming payment in case of contracts entered into with customers. And the trader or the builder for these practical purposes may demand, in addition to the price agreed, an extra fee only in the case that the consumer has expressly acknowledged the obligation to make such an additional payment. The Norwegian rules are quite similar, but from reading this Estonian law and comparing it with Norwegian law and practice, it might be a little bit easier for a contractor to claim extra payment in Norway than it would be in Estonia, possibly. I don't know the system in Estonia, but from my point of view, the Estonian law seems perhaps more strict than the Norwegian rules, which are perhaps a little bit more flexible. Not that much of a difference, but it's interesting and there might be a need to look into those sort of things in the specific contract which is to be signed.
Henrik,
yes,
take
yes.
a comment?
Yes, please.
Thank you. I think your conclusion is correct. I will tell, in Estonia, according to the Law of the Obligations Act, paragraph 99, subsection 1, it says that the trader, in that case our builder or the service provider, shall not have any right to claim against the consumer to whom the person dispatches goods or provides services, to ask money for the services for which the consumer did not order. So this means that if the service provider will just provide a service to a consumer without any pre-agreement, then the service provider will simply take a risk that that service provider will not be remunerated. And this is quite a big risk. So how is it in Norway?
Well, Janus, your statement kind of confirms my interpretation of the Estonian law. It is very absolute in my opinion. In Norway, there are exceptions. The parties, both parties, can demand that the price be adjusted as a consequence of changes or additional work. The contractor might see the need for some additional work. The consumer might see a need for some additional work or changes for that matter. And of course, as we have earlier mentioned, everything can be agreed upon between professional parties. When it comes to a professional party on one hand and the consumer party on the other hand, there are some limitations as to the Norwegian law, but in this case, everything can be agreed upon. But in order to demand the price, for instance, be adjusted, that can only be done in certain cases in Norway. You have to sort of the party that demands additional price have to make that demand, and the same time that the demand for adjustments be put forward. So one cannot sort of demand additional work or changes at one point and adjusting the price at a later stage, for example. Anyway, there are some exceptions in the Norwegian law, which I wasn't able to find in the Estonian law. It seems very absolute in order to protect the agreement and to respect the agreement. Maybe a little bit easier to get away with changes in Norway on this point. I don't know. It might be. Things to consider in the specific situation.
So, Henrik, to conclude, then if in Norway the service provider builds and builds without any previous agreement on behalf of the consumer, in that case the consumer is a natural person. Let's say there was an agreement before to build a house, but the service provider also decides to build a terrace. What is the possible outcome of this action?
Well, the general rule, of course, is the same in both countries, that if there is agreed a price or a certain amount of work, that agreement is to be respected. But as I mentioned, there are some exceptions. I can look it up for you to be specific here. I think I'll just translate the Norwegian law. The parties may demand adjustment of the payment as a consequence of changes and additional work. And of course, the main provision is to the degree that is agreed upon, or agreed upon in a separate agreement about the changes or the additional work. This is quite common, that an additional agreement for changes or additional work is made. But other than that, the price of an agreed... did I hear you correctly that the price had been agreed? Is that the case?
Yes, usually the price is agreed, yes. So is the object.
Yes, then the price can only be adjusted if the demand is put forward at the same time as the demand for changes or additional work, or to the extent that the other party, for example, like you said, if the contractor builds a terrace in addition, if the customer then had to realize that the changes or the additional work would lead to an additional price, then the contractor can demand that the price may be adjusted. That is what follows directly from the law. And it also says that if the price is to be adjusted due to these regulation, the adjustment is limited to a necessary increase in costs or possible savings in cost on the consumer side, with a corresponding change in the contractors. I don't know the word in English, but when a contractor buys materials, for example, he has to earn a little bit money from that. So the price he buys the materials will be a little bit lower than the price he sells the materials to the consumer. You know, the difference between ingoing and outgoing materials. So it is to compensate for those kind of costs, or compensate for the corresponding savings on the consumer side. So there are some limitation, and it has to be tied up to the costs and savings of the respective sides, the contracting parties.
So here we come to a question that if the parties did not agree on the prices of the materials to be used, and especially in the COVID times, what has happened is that the prices have gone up, at least in Estonia,
Yes.
I suppose also in Norway.
Yes.
Then can the contract be adjusted for the behalf of the service provider who also brings in the materials, or not, because the costs has gone up and the service provider will not get his profit, essentially?
Well, there is no easy answer, but in a situation with, I mean, we have also seen the increase of material prices over the last months. It has been quite astonishing how the prices have gone up. So then it could be argued that the consumer in this particular case had to realize that this was foreseeable, but it's also the adjustment rules are in general restricted to either changes to the agreed work or additional work. So if things are going to be done in a different manner, or extra work is supposed to be done, that is sort of the main scope for the right to claim adjustments in price. It's not very easy to get a definitive answer. So if the price is agreed upon, I would say that is it's not very likely that the contract can show that materials prices have gone very, very much up, and maybe even though one is have a financial loss because of this. I mean, an agreed price is an agreed price. So it would take quite a bit in order to succeed in such a claim on the contractor side. But again, there are of course the general obligation rights that say if the fulfillment of a contract becomes unreasonable for one of the parties, that contract might be amended or even be deemed void. So there is a sort of a safety valve in Norwegian agreement law. It takes quite a bit to succeed with such a demand, but the example with material costs gone through the roof, well, there might be a chance that a Norwegian court would decide that that sort of contract is unreasonable and has to be adjusted.
At least in the B2B world, it's extremely hard to get compensation for increased material prices, because you should sort of have calculated this in, and there is always a risk that there will be a price increase. So in these days, it's really important to take this as a precaution or a term that our prices are only valid until a certain amount of increase or decrease.
Yes.
I actually got a kind of answer to my kind of question. My first question was, my name is Mari Kullerkupp. I would like to call myself a Nordic wizard, because I can't define exactly what I do. Yeah, I mainly work with in between Estonia and Norway with many different projects and stuff. So, but right now I am kind of speaking out of an experience with a client of mine producing element houses, and exactly the same situation came up just recently about how to proceed with pricing and the price increases and so forth. And my first question was going to be if we are talking still about private customer or contractor or business to business, because my experience is that, for example, business to business contracts, it was a positive outcome because we stated or we agreed upon writing this clause into the agreement that we can't decide on the prices per today because we see the price increase more or less day by day. So the prices we are saying right now will be valid, let's say, in for I don't know, weeks or months, and then we will revise the prices both ways if we have to, I don't know, maybe kind of pay back to the customer, or they will have to pay a bit more. It would be like 50-50 more or less. So that was, I see that it's always worth asking or suggesting things before we get afraid of the results. Yeah.
Thank you.
Absolutely.
As a comment, just today, I had the chance to reintroduce myself with a court practice from our Supreme Court. And the resolution which I have right now is in mind is from 2010, from the previous economic crisis, and it says that the entrepreneurs who work in the field of building, they must foresee the changes in the markets. By stating is that they essentially carry the risk if it has not been otherwise marked down in the contract. B, from my experience, changing the balance of the contract, this means essentially readjusting the price. I'd say things get quite complicated if the contract was concluded during the time of the COVID already, when there were already fluctuations on the market, and now come up with a statement that, listen, I didn't foresee this fluctuation. I would say that the percentage of success is not so great for this one. Thank you.
I just have.
Yes.
Yeah. Is it okay?
Please go ahead.
Exactly the same situation about going into a contract in these times. When you, for example, start with negotiations and make offers, price offers, let's say year in advance, 3 years in advance, because as we probably all know, the process between an Estonian and Norwegian company can take, of course it can take a day or two or a week, but it tends to take months, if not years, start making the price offers. Like years before the current situations, then you can't foresee like the situation we are in right now. I do understand logically. So when you find a partner who agrees to like take the risk as well for the sake of good partnership, then I find this just very positive that these companies, these kind of relations still exist.
Absolutely. The best outcome is nearly always that one can be flexible and agree without having to go to court. But I mean, foreseeable and unforeseeable changes are always a risk, and this spires on to some of the classic legal question: who is which party is the nearest to suffer that loss. Is it the party that has offered to do these services, or is it the receiving end? Maybe it's a little bit of both of them. But what we see also in our business here at our legal firm is that it's quite common in contracts to have a clause that says the contractor has the right to adjust the price according to material prices, for example. So if that is agreed upon, then there won't be a problem. But in a fixed price, there will always be a risk, and if there is a loss, who will be the nearest to suffer that loss? And if a contractor has made a very detailed, specific offer, perhaps the court would rule that that party would have had the opportunity, or maybe should have specified or made a reservation for increase in material costs, for example, and therefore the judge might decide against that party. So that would be my general answer if I have understood the question correctly. And it would be even more difficult when the other party is a private consumer. And partly because a company is generally viewed to be able to take a loss and deal with that loss in a way that a loss would affect a private customer potentially quite hard. This would also be the case with a company, of course, but yes, relatively it would be even more difficult to win forward against a private consumer party who is not a professional, don't know the rules, etc.
Thank you, Henrik. A short comment about the price and the budget. In the Estonian law, if the parties agree upon in the contract that the Estonian law is applicable, then unless it has not been agreed differently in the contract, it is assumed that the budget is binding. This means the fixed budget will be the assumption. So to keep that in mind.
Yes, and also the Norwegian rules also they differ a little bit between a price estimate, or the offered price, and the price that is agreed upon. Sometimes the offer or the price estimate is accepted by the other party, and then the price is agreed upon, but it might still say in the offer that this is an estimate. So if the court, if there is a disagreement and the question goes to court, it would be up to the judge to decide, was this price just an estimate, or is it the agreed final price? If it is considered an estimate, then there are rules that say that it's easier to adjust the price than if the price is considered a fixed price. And with consumers, there are specific rules stating that the contractor cannot charge more than 15% in addition maximum. If there is given a price estimate. Okay. Any other questions concerning additional price before we move on? No?
No, the audience is excitedly expecting for the next bullet.
Excellent. We'll move on then. The next point, I am told, is not applicable to building contracts, where we will just skip that point. But the third point here says no apparent duty for contractor to provide security or guarantee. This I couldn't find such a rule that in the Estonian law, the Obligations Act, which require a contracting party to put up security or put up a guarantee. So I had to ask my good colleague Janus Stern, and the answer, this is true. It used to be an obligation, if I remember correctly, but no more. This is a little bit different to Norway. Mr. Opseth has talked about the standard contracts, which are usually used between two professional parties. The obligation to put up security, to use that expression, are often included in those standard contracts, both on the, if we take construction, for example, both with the contractor and the customer, so to speak. So they both have to put up a certain security. But of course, as we mentioned, anything can be agreed upon. But if it hasn't been agreed upon, then the general rule is that both parties have to put up a certain security, 10-15% of the contract sum, for example. When it comes to a building contract between a professional party and a private customer, then the contractor is obliged by law to provide security. And this derives from paragraph 12 in the law of constructing residences for private customers. They are specified. The guarantee is supposed to cover a sum that is at least 10% of the total contract sum. And also, this guarantee is to be put forward by a Norwegian insurance company or another company, financial company, that is entitled or licensed to operate in Norway. And this is a security for the private customer. If, for example, the contractor goes bankrupt, then at least 10% of the sum which is paid is claimable towards on the guarantee. So the contractor has to put a guarantee forward through a insurance company or a financial company in order to secure the consumer's claim when it comes to delay, breach of contract, and other obligations which the contractor either can't or won't pay. The private customer is not obliged to put forward a corresponding guarantee. Of course, it can be agreed upon, but no obligation. So this is quite an important thing, I think, to remember for a contractor building a private house for a private customer in Norway, because the obligation is there by law, and the consumer has the right to withhold all payment until that proof he has received proof of that guarantee or security. So a little bit different there between Norway and Estonia. My plan now is to move forward.
I have an extra
questions to guarantee. Yes, please.
For how many years must be this guarantee be? How many years it must belong to the customer? It's 5 years, 10 years?
5 years,
Five.
but I mean the security is to be put forward before, as I mentioned before. The contractor can't claim any payment before that security has been arranged, and until the project is finished, the customer takes it over. That guarantee covers the full sum, so at least 10% of the price, the total contract price. After the consumer has taken over, this is reduced to half, so 5% of the total contract price, and that lasts for 5 years after the private consumer has taken over.
Okay, I understood. In Finland,
Thank
it's 10% for 10 years.
Oh, really? So good conditions for private consumers in Finland then. Yes, interesting.
Henrik,
Thank you very much.
I also do have a question. Before, yes, indeed, according to the Estonian law, the builder was obliged to give a 2-year warranty after the building was finished. Now we don't have it anymore. We have chosen a more liberal way. Is there any such a rule in Norway? Additionally to the security you just told us about, is there a automatic warranty for the private person consumers, or even businesses in that case?
The way I understand warranty is that there is no law required warranty as such, but if the contractor has given a warranty, then there are certain rules concerning that. If a guarantee has not been provided, then there are the normal rules to notify. I mean, for example, if a private customer discovers malfunctions, deficiencies with his house, he has to notify the constructor as soon as possible. I will talk a little bit about those notification rules later, but in general, the party which discovered the deficiencies must tell the contractor within 2 years, unless the contract object is a thing that is meant to last considerably longer than 2 years. If we take an example of a private building, for example, most of that structure is obviously meant to last more than 2 years. So then the extended time limit to put forward such a claim is 5 years. But after 5 years have gone, after the deficiency was discovered or should have been discovered, then the party, the consumer, no longer has the right to claim reparation for that deficiency. So in general, when it comes to building, I'd say 5 years. That is the maximum, but one still has to notify as soon as possible.
Back to the security for private consumer. It's 5% for 5 years, but is it like the same as in B2B, where you have reduction each year? So it's 5, 4, 3 to 1% the last year? Because that's the normal in the construction business in general.
According to the law, between a professional and a customer, the short answer would be no. I can't see any reduction in that 5%, and I've also had cases which this question has been brought up, and 5 years after taking over, within 5 years, the guarantee is supposed to cover still 5%.
Okay.
And that is regulated by law. And as I mentioned earlier, these, as long as it's specified within the law with the consumer, then it is actually, I wouldn't say illegal, but you can't win with such a claim if the claim derives from an agreement that is not according to this law.
Thank you.
Okay. Thank you. Any more questions about guarantee, security, construction? If not, I think I'll move on to my next slide, number 2. I discovered some regulations in the Estonian law, which concerns something called distance contracts. Some technical that I don't have the law in front of me now, but I could take it up. But it concerns agreements, cross-border agreements, where a thing is to be delivered abroad. And then the Estonian law says that these rules apply in the same manner to all the countries in the EU. Well, this was a little bit interesting for me, since regrettably Norway is not a member of the EU as such. Norway has an agreement, a treaty with the EU that says that nearly all of the EU directives are applicable in Norway also, except for agriculture and oil and certain other exceptions. But it seems to me that it is a little bit unclear whether these rules concerning distance contracts also apply to Norway, as Norway is not a part of the EU. Norway has this agreement with the EU, the EØS agreement treaty, but this is, if an Estonian company has plans to sell something to a receiver in Norway, or the contract is supposed to be fulfilled in Norway, even though it is agreed upon in Estonia and so forth, it might be a good idea to check as to whether these rules can be directly applied in Norway or not. It is a quite big and complicated subject, so I would just limit myself to mentioning it and to recommend that these things might be a good idea to look into when it comes to these distance contracts and Norway. Yes, my next point concerns measures when a contract is breached. In Norway, in general, a contractor, to use that example, if something is wrong with the construction or whatever, the contractor generally has a right to amend this problem or to cure this problem, as the Estonian law puts it, before the other party can demand, for example, reduction in price, a delivery of a similar object, or even cancelling the contract. So in most cases, a contractor has the right to cure or amend his delivery before the other party can put other claims forward. This might be very similar in Estonian law, but yes, I can hear that it's probably the same rules. To me, it wasn't perhaps that clear. So yes, again, a thing that might be taken into consideration before the risk is calculated, before getting into a contract.
This is a very good point to talk about. Thank you for clarifying the Norwegian part. From the Estonia, the contractor does not per se the right to cure the breach. But if the consumer, the private person or a business, doesn't matter, does not give the right to cure the breach, then it is a bit, not just a bit harder, but a lot more complicated to use other rights against the service provider. So in short, it is always a good idea to give supplementary time to fulfill the obligations. And then proceed with full force. Otherwise, the court might say that the one who bought in the services was just acting in bad faith, or misusing his rights, and therefore the claim cannot be satisfied. To make it very short and clear.
Yes. And of course, even though the contractor has the right in most cases to cure, the cure, of course, is to be performed in a timely manner without due delay. The consumer, or this applies to both consumers and other counterparties. Is not obliged to sit and wait forever, to put it that way. But the right to cure is in general quite extensive in Norway, and it's interesting now to hear that perhaps the right to cure is not that extensive abroad. So yes.
Henrik, there's also a question from the audience.
Yes, please.
Yeah, I have a question about when the customer gets someone to repair or make the cures at, let's say, a house or something, without the consent from the producer, let's say, without the producer even knowing about the defaults, and going on with the repairs, and then telling the builder, it was your fault, I needed to be done, and I did it, now you have to pay. What should be the contractors or the builders or the house providers state in this? Because if they don't know that they were actually wanted to cure something, they can't fix it, you know?
I agree with you, and this is I think it's I'm pretty comfortable to say that if the contractor hasn't been notified, then it would be pretty difficult for the consumer to get full compensation. But if it is evident that there was a deficiency, and that this deficiency had to be cured, the other party just might succeed in claiming back some of the expenses, because often the contractor can save a lot of money by doing these reparations or amendments themselves. If they have to pay someone else to do it, it might be twice the price. So that would be unreasonable. But a party always has a duty to notify when the contract is breached, and if this isn't done, it is very, very difficult to win forward with a claim in afterhand. There's difficult to see any good reasons why one shouldn't notify, at least. But if the party notifies and tells that 3 weeks is, for example, is a reasonable, you should be able to do this in 3 weeks, and the contractor says no, or doesn't say anything, and doesn't do it within 3 weeks, if the court then agrees with the other party that 3 weeks is reasonable, then the contractor who should have cured might well be liable. So, but in your example, without notifying, it is very difficult to win forward with such a claim.
Thank you, Henrik. It's essentially the same also in Estonia. Plus,
yes,
if the one who ordered the service now lets it repaired by somebody else, by a third party, then the result is that there is not much evidence to work with afterwards to prove that there was a fault in fulfilling the contract, and that makes things a lot complicated. But there is a possibility in Estonia, nevertheless, to also proceed without notifying. And it's these cases when the mistake was so serious or such evident that it can be said that the breach was, let's say, even planned, or it was breached by taking the breach itself into account. Then it's a whole matter. But otherwise, yes, the principle applies just the same in Estonia as it is seems right now in Norway.
Absolutely, and of course, if water is leaking in, for example, then it would be a enormous damage if this isn't amended in a quite short time. But even though in most situations there is a possibility to notify. A short phone call, an SMS, an email saying water is coming in, we have to fix it, call me straight away. And at the same time, while waiting for the answer, something has to be done. I mean, that's a different matter. But yes, so every situation is different, I think we can say. But yes, to go back to where we started, the right to cure on the contractor side in this example is quite important in Norway and quite extensive.
I just thought of one thing. If the contractor has this, let's say, 5 years guarantee, in front of the customer, but the customer breaks these rules or breaches the contract in such a way as I just described, what happens then? The guarantee still stands, even though one counterpart has...
The guarantee still stands, but the contractor would, of course, refuse to pay for some work that he didn't know was performed.
But let's say the bill is not paid yet due to let's say the bill or the last amount or however we call this is not paid by the customer yet, and they say that I am holding back this amount of money, or I'm holding back some portion of the money because I had to do this job, or I had to have this job done because there was that and that problem, but the producer or the contractor hasn't been informed. Then the contractor is losing money. I know that I understand and I heard, and it's logical that every company and an enterprise has a buffer and so forth on every price and everything. But it's like a question of trust or professionality, or how you want to call it. You know, what should be, or what would be the explanation or the guidance in such situations.
Yes, thank you. Well, of course, there is always a risk that people won't pay. And it's an unfortunate situation for the contractor, of course, because then the contractor has to go to court and prove that the claim is legitimate. For example, to get a verdict that says the customer holding back money is not legitimate. So then the customer will be forced to pay according to contract. But this is after a court case. Those are expensive. It takes a lot of time, etc. In a situation like this, it would be very favorable that the contractor has agreed a certain security from the private customer. So because it's very, very, very difficult to force people to pay, and it's a time-consuming process and an expensive process. If one has a guarantee which is agreed upon, it would be much easier to walk away from the contract or to fulfill the contract without loss. But of course, it's always a problem when people don't pay, and but the contract, as the other presentators have mentioned earlier, with the standard contracts and so on, the contract will be the main legal source in most of these cases. What is agreed upon? Then if someone does something which is not agreed upon, then the simple answer would be that person has breached the contract, and that the contract must be fulfilled. But in practice, I mean, this could take a lot of time and a lot of energy and a lot of money also. So there is a problem.
Yeah, if I can comment, very often this can also be a matter of circumstances, that what was most reasonable at the time. And you can also, if these things are happening, then it can also come down to what was most beneficial at the time, what was economically most reasonable, and so and so. So it's always very difficult to conclude on such cases when you don't know everything. Usually the picture is a lot broader than just money held back, something been done. It's usually some more circumstances concerning this issue. And if the customer, I think at least in the professional world, if the customer found a solution that is reasonable to believe that is most beneficial for all parties, then they can go forward and have it sorted if it's critical to have it fixed. So in the court case, I think that then they will look at what, have someone lost anything, or was it actually maybe beneficial even for the supplier to that the client did like he did. So I think that's almost correct.
No, I agree with you totally. It was basically to prevent maybe coming to court at all, to be able to resolve such situations, Massachusetts, in forehand, you know. And there is also, as far as I have learned or experienced, a Norwegian private customer is much more protected than the Estonian one, as far as I understand. And then when you have a customer to business or business to customer relationship, then the businesses are more afraid maybe because the Norwegian customer, private customer, is kind of a holy cow, you know.
Well, that's one way of putting it. I would say that private customers are generally well protected in Norway. I don't know whether they are protected better in Norway than in Estonia, but what is evident is both Estonian and Norwegian rules differ when it comes to an agreement between two professional parties and one professional party and a consumer. The consumer is, in most cases, better protected than a professional party, and there's pretty natural reasons for it. Legally or legally technical, so to speak, is that in Norway there are separate laws concerning consumer contracts and other contracts. And in most cases that I know about, the consumer laws cannot be deviated from in an agreement. So it's not possible to win forward when in a claim in a contract with a private customer, which is different from what is required by Norwegian consumer laws. So yes, holy cow, yes or no? Maybe, but there is quite a difference between consumers and professionals.
I think this was that. I probably would have many more questions, but it would take a bit too long time, I think. So thank you.
Well, I rely on my good colleague Janus Stern to speed me up but I enjoy talking to you, and as long as I don't hear anything else, I will just press on. Any other questions concerning breach of contract or an cure in particular?
Not currently, not from the audience. You've done a fantastic job so far.
Thank you. We'll move on then. One of these measures which can be applied concerns damages. Damages, as we all know, compensation for a loss. As I could read from the Estonian Law of Obligations Act, in obligation, it says that it doesn't really matter whose fault it is when a loss is suffered. So the only exception for that a contractor, for example, shouldn't be liable for compensation for loss is in the event of force majeure. Of course, there are also limitations if it is. I'm sorry, I will rephrase it. The contractor, sorry, will be responsible for any loss on his side, whether it is the contractor company itself who has the loss derives from something the company itself has done, or subcontractors, or anyone else. The contractor or the party in the contract will still be liable for that economical loss. The only exception seems to be in the event of a so-called force majeure. Some people call force majeure an act of God. Examples are war, maybe in some cases pandemics, and other large crises which would make it unreasonable for the contractor to be liable to pay damages. In Norway, there is, of course, an exception for force majeure here also, but the contractors in Norway, if we just read the Estonian law, it would seem like the contractors in Norway have a couple of more ways out, so to speak, when presented with a claim for damages. And what is the contents of these rules are that if it was beyond the contractor's control to foresee these consequences, then the contractor will not be liable for loss, which is made on the other contracting party's side. So force majeure is a pretty, it takes quite a bit in order to describe a situation as force majeure. Whereas in Norway, with the rules that it has to be beyond the contractor's control, maybe a little bit easier to get off the hook, so to speak, but not very much easier. Because, for example, if a contractor has a subcontractor which has gone bankrupt or, well, any other reason, the main contractor still cannot blame the subcontractor, because the main contractor had the choice of choosing which subcontractors to use. So in that sense, a Norwegian court would say that this is not beyond your control, even though the main contractor hasn't done any wrong at all. This is the risk of going into contracts, and I hear that Jan Staden has some comments, so please go ahead.
Thank you. No, in this case, I had a question or two. First, in Norway, in Estonia, the main contractor is always liable for the mistakes the subcontractor does before the ones who order for the service. Is this the same also in Norway? Second, in Estonia, it's quite common to agree upon the force majeure events, and by doing that, closing the list. Is this also common in Norway?
First question. In Norway, a main contractor is only. Let me rephrase. A main contractor in Norway is always responsible, except in the cases that are beyond the contractor's control. It's quite narrow. It's not very many cases which are beyond the contractor's control, but it would seem that force majeure is even more narrow. I don't really know any better way of explaining this. So I think I'll just move on to your next question, whether it is common to agree upon force majeure and closing the list in Norway. Yes and no. Some contracts have exceptions for force majeure and a list of which situations are exempt. Some contracts don't. But what I will emphasize at that is, since the pandemic hit us, it seems that it has become much more common now than it used to be to have a force majeure explicit clause in the contract.
Yes.
Was that adequate?
I can confirm that this is more and more common, but also it's becoming more and more difficult to claim force majeure due to COVID, at least, because now it's a known thing, and the companies or the contractors should by now have established routines or tools to handle this situation. So some agree maybe on some things regarding force majeure about COVID, but it's getting more and more restricted now.
Thank you. And I just might add an example. It's not from building law. It is from employment law, Norwegian employment law. There are certain rules which apply in force majeure situations when it comes to an employer's right to terminate some of the employees and so on. There are some special rules there concerning force majeure, but the Norwegian workers' unions and the Norwegian employers' union, one or two of the most important ones there, have sort of determined that COVID is not a force majeure when it comes to these rules in employment law. So that would sort of be the same situation which you described. It becomes more and more difficult to claim force majeure when it comes to COVID. And I of course agree totally with the rest of your points there also. Just an example. Yes. Should we move on? I don't know how many minutes I've spent now, but I've still got a few points.
Please go ahead.
Yes, this is the last slide with the comparison, and after that, my final slide would be just a general slide with some general advice from a Norwegian lawyer, all free of charge.
Okay, Henrik?
Yes, yes.
It seems that the other part of the event is also coming up, so I do apologize, but it seems that we have approximately 5 minutes left.
Okay.
So we have all been quite invested into the topic. It has turned out quite good, quite well. Let's see now what we can make out from the last 5 minutes.
Excellent. I'll speed up, and I must say I'm delighted that that there are this many questions. This is what is important, if there is a dialogue and not just a presentation. So thank you very much to all the audience. I'll just move quickly through the differences. Paragraph 642 in the Estonian law, actually, it seems like it determines a sort of, I described it as a reversed burden of proof in consumer contracts. And it seems to me that if the consumer detects a malfunction or deficiency within 2 years upon delivery, this concerns building in accordance to building code, just to point that out. Then it seems like it's presumed that this malfunction or deficiency exists, and the contractor has to prove that everything is all right. If this is correctly understood from the Estonian rules, then there is a difference to Norway. In Norway, if one has a claim, it is, in contracts at least, it is nearly always the person who has the claim that has to prove that this claim is legitimate. So no apparent parallel in Norwegian law for that paragraph in Estonian law, at least. I'll just move quickly through. I've got 5 minutes. Paragraph 644 specifies the relative time limit for notification. It's good that the Estonian law has this regulation. In Norway, the rules are the same, but they are not listed in the law. Basically, you have to be a lawyer to know them, because they derive from Supreme Court practice. So I would wish that there was such a rule in Norwegian law. It would make it easier and more accessible to the people using the law, but there isn't. So, but I can tell you now that the time limit, or sort of after you discover a malfunction, you have about 2 months maximum to notify. In Estonia, it is written in the law. It's not in Norway. It is not. Prescription is a difficult word. What it means is that if you wait too long with putting a claim forward, the claim will go away. There might be a little bit different when the prescription period starts. I think, Janus, that the prescription time limit is 3 years in Estonia in general. Yes?
In general, with the contracts, it's yes, it's 3 years is the final due date for everything. This is to keep in mind in contractual relations. Mm-hmm.
Yes. So the same main rule in Norway, at least, but there might be some nuances or differences as to when these 3 years start. Can't give you a sort of an answer, a final answer, but it might be some differences here in certain situations. The contractor in Estonia has a right to a mortgage when engaging in building projects. In Norway, a contractor does not have that right by law. So it's down to the contractor to remember to agree upon such a mortgage if that is needed. I think I have a couple of minutes left. So I thought I'd just give some general advice before entering a contract from a Norwegian lawyer's point of view. First thing I would recommend is that is specified as much as possible who is to do what. The contractor's duties on one hand and the other party's duties on the other hand. Usually when I write a contract, I state that the contractor shall 1, 2, 3, 4, 5. The other party shall 1, 2, 3, 4, 5. So that there is, if something is to be done, who is to do it? That is the question or the problem to avoid. Who is to do what? Specify as much as possible. Again, how much, quantity, price, quality, specify as much as possible, be specific. The general recommendation. And that is, it's much better to include too much in a contract than too little. Saves you money to court cases and lawyers and etc. It's also very important to specify when these obligations are to be fulfilled. Within 2 weeks, within 10 days and so on. Generally, I would recommend the easiest way is to simply put a date. Then there can be no disagreement on when the contract is or the contract obligations are fulfilled or not. I have written this point in bold letters because this is perhaps the most important thing with a contract, in my opinion. Specify in the contract what should happen if the contract is breached. A contract might be as specific as possible, and it might be a very, very good contract. But what if the contract is breached? What is to happen then? It would save a lot of time and energy if it's specified in the contract what should happen. For example, daily penalties, as described in the standard Norwegian standard contracts, damages, and security guarantees, when is the guarantee due, so forth. Always better to include too much than too little. And finally, yes, I've already mentioned it. Always consider to agree upon security or a guarantee. It makes things very, very much easier in order to avoid a legal process. So sorry about the limited amount of time at the end, but I think time well spent. I'm delighted that there were so many questions from the audience, and the most important thing is that we talk together. I would much rather do that than just present something for you. So I would like to take the opportunity to thank you very much for inviting me. Special thanks to Janne Stern again, and to the people at the embassy. And I look forward to meeting you in person at a later date. Thank you very much.
Yes, thank you. Thank you, Ola. Henrika, but I'm afraid I didn't hear the applause. It was quite strong. So yes, thank you for the presentation. Thank you, Ola, also for the same. I do hope that we can repeat this again in the future on another topic. And now we will continue with the next part, which is the quiz, food quiz, and communicating. So Henrik, you are welcome to join us, despite that.
Thank you.
But till the next time, thank you again. Bye.